North Carolina law governs the amount of tenant security deposits, how and where they must be held, and how and when the money can be dispersed. The Residential Tenant Security Deposit Act is in Chapter 42, Article 6 of the North Carolina General Statutes, beginning with Section 4250. You can read and print your own copy by going to the North Carolina General Assembly's website and clicking on Statutes under Shortcuts. The Residential Tenant Security Deposit Act allows owners to charge a security deposit of up to 2 weeks' rent if the tenancy is week to week, 1.5 months' rent if the tenancy is month to month, and 2 months' rent for terms greater than month to month. So, if a tenant signs a lease for 6 months or a year, for example, the deposit amount can be up to 2 months' rent. Once a security deposit is received from a residential tenant, the Act requires that it be deposited into a trust account with a licensed and insured bank or savings institution in North Carolina. This requirement applies to both property managers and individual owners. The Act includes a limited exception for an individual owner who may instead furnish a bond from an insurance company licensed to do business in North Carolina rather than using a trust account. A licensed broker doing property management does not have the option to provide a bond. A broker must always hold tenant security deposits in a trust account. Within 30 days after the beginning of the lease term, the landlord or his broker must notify the tenant of the name and address of the bank where the deposit is being held. The residential rental contract form, created by the North Carolina Association of Realtors for its members, includes a space for providing this information to the tenant. If the owner has chosen to buy a bond instead, the owner must give the tenant the name of the insurance company providing the bond. A real estate broker must keep particular records about the security deposit. The broker must have a journal or check stubs showing funds received and dispersed by the broker. The bookkeeping entries will have the amount and date of each security deposit and a reference to the matching deposit ticket. Brokers must also keep a security deposit ledger. The ledger is specific to the rental property or the owner of the property. Along with identifying the owner's name, tenant's name, and the address, the ledger must show the amount and date of the deposit and from whom the security deposit was received. At the termination of the tenancy, the disbursement of the deposit must be shown in the appropriate amount to the owner and/or tenant. Brokers must also keep a copy of the deposit ticket itself. The deposit ticket must identify the purpose of the money as a security deposit, the identity of the person who paid it, the name of the tenant, and a reference to the matching ledger sheet. In the case of numerous deposits, brokers may keep this information on a supplemental deposit register. At the end of the tenancy, the Act allows certain deductions from the security deposit. These include things like the tenant's non-payment of rent, damage to the premises, non-fulfillment of rental period, unpaid tenant bills that become a lien on the property, cost of re-renting after breach by tenant, cost of removal and storage of tenant's property after summary ejectment, and court costs. Remember, brokers must keep records for 3 years after the lease ends, including the trust account bank statements. These records can be kept on paper or electronically. For more information about tenant security deposits, trust accounting, and renting residential real estate, visit the Commission's website at ncrec.gov.